Auzubillahiminash-shaytanir-rajim. Bismillahir-rahmanir-rahim. Today's our topic of discussion is uh, Basic Principles Committee Report 1952, the notes of which I have shared in your WhatsApp group. As discussed earlier in our previous lectures, the first report of the Basic Principles Committee was severely criticized, particularly in East Pakistan, by postponing its consideration. In accordance with the wishes of the people, Liaquat acted in a democratic way. The report was referred back to the Constituent Assembly, on which they invited proposals and suggestions from the public by January 1951, and a subcommittee was appointed to examine them. The subcommittee made its report to the Basic Principles Committee in July 1952, and it was presented as the second draft to the Constituent Assembly by the then Prime Minister Nazmuddin on 22nd December 1952. तो जो फर्स्ट रिपोर्ट थी बेसिक प्रिंसिपल्स कमेटी की वो उसको publicly बहुत ज़्यादा within the Constitutional Assembly and outside the Constituent Assembly, that report was criticized. The main criticism on that report was that by the East Bengal, people of the East Bengal, because that report suggested the equal representation in the upper house of the legislature. Although the population size of the East Bengal or East Pakistan was greater than or more than the West Pakistan, that's why the Bengalis or East Pakistan, citizens of East Pakistan demanded their representation in the upper house of the legislature according to their population size. So, Liaquat Ali Khan, behaving in a democratic way, sent the same report to the Constituent Assembly back to reconsider it. To the Basic Principle Committee to reconsider it and submit a new report in Constituent Assembly. The subcommittee of Basic Principles Committee made its report in July 1952 and presented the second draft of the uh, proposed constitution in on 22nd December 1952 by the then Prime Minister Nazmuddin in uh, Constituent Assembly. A salient features of the report are, you can say, the second draft of the Constitution were. The first one was the objective resolution was adopted as a preamble to the proposed Constitution as it is nowadays in the Constitution of Pakistan of 1973. The head of the state was required to be a Muslim and to be elected from a term of 5 years at a joint sitting of both the houses uh, of the federal legislature. The head of the state could not hold office consecutively for more than 2 full terms. So, the head of the state, like we have the president of Pakistan nowadays, So in the second draft of proposed constitution, there was a condition that head of state must be a Muslim and he should have uh, confidence of both the houses of the legislature, and he could not hold the office for more than two consecutive uh, terms, full terms. The prime minister was to be appointed by the head of the state, who also appointed the ministers on the advice of the prime minister. The council of ministers was to be collectively responsible to the house of the people only. So the prime minister would be appointed by the head of the state, and other ministers on the advice of prime minister. The council of ministers, like we have cabinet these days, was uh, responsible to the uh, house of the people only, means the lower house. So the council of ministers was collectively responsible to the house of people, the lower house of the legislature. Similar in uh, United Kingdom, and the cabinet nowadays is responsible to the lower house. The proposed federal legislature under the second draft comprised two houses of parliament as in the first draft. The House of Units was to consist of 120 members of 120 members. The legislature of East Bengal was to elect 60 of their members according to the principle of proportional representation by means of a single transferable vote. West Pakistan seats were to be allocated as follows, also be to elected according to the principle of proportional representation by means of a single transferable vote by their respective legislature. So the proposed constitution suggested two houses of the legislature, means the bicameral system was introduced in the second draft of the constitution. The House of Units was to be consist of 120 members, means the upper house has had sorry upper house had 120 members. The legislature of East Bengal was to elect 60 of their members according to the. So out of 120 members, 60 members would come from East Bengal. uh, these members of House of Units, the upper house, would be elected by the provincial legislature of East Bengal. Similarly, the same situation was in West Pakistan. Uh, so here, the Basic Principle Committee accepted the demand of East Bengal or East Pakistan people to give them representation in the upper house, House of Representative, House of Units, according to the population size. So the if you look at the notes I shared on the in your WhatsApp group, the proportion of the seats was as under. In Punjab, 27 members would come from Punjab in the upper house, the House of Units, 8 from Sindh, Northwest Frontier, NWFP nowadays KPK, 6 tribal areas, 5 Bahawalpur, 4 Balochistan, 2 Baloch states to Khairpur to capital of Federation for 60. That was the West Pakistan. The House of the People was to consist of 400 members, of whom 200 were to be directly elected from East Bengal and 200 from West Pakistan. The seats allowed to West Pakistan were divided as follows. So the lower house members, the members of the lower house would be elected directly by the people of Pakistan, and the allocation of the seats were as under: the 200 members would come from East Bengal and 200 members of lower house would come from the West Pakistan. So uh, from West Pakistan, 90 members in lower house would come from uh, Punjab, 30 from Sindh, NWFP 25, tribal areas 17, Bahawalpur 13, Balochistan 5, Baloch states 5, Khairpur 4, capital of Federation 11, total 200, and 200 from East Bengal or East Pakistan. Uh, Total membership of the lower house would become 400. Under the second draft, the House of the People was to enjoy the real authority. Here, one thing to note: the House of People is the lower house, and House of Units is upper house of the legislature. So, real authority was vested in the House of People, the lower house of the legislature. The House of Units could only recommend a revision of hasty legislation. All money bills had to originate in the House of People, like in United Kingdom. In case of any conflict between the houses, joint sittings of both were provided for, in which a simple majority would decide the issue. The second draft brought the principle of parity between East and West Pakistan as most important contribution uh, towards solving the problem of representation, and it claimed to bring about a constitutional balance of power as well as of the responsibilities between the two wings of Pakistan. So, in the second draft, the members of Basic Principal Committee tried to solve the issue of representation in the both houses, in the lower and upper house of the legislature, and fulfill the demands of people of East Pakistan. Seats were to be allocated to communities in the House of People. Now, uh, 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 as you know, we have still a quota system in the lower house. We have reserved seats for women, for minorities, for technocrats, and peasants, even in our local body system in union at the union council level. That principle uh, uh, came from the report of uh, Basic Principles Committee 1952. Seats were to be allocated to communities in the House of People. The single-member territorial constituencies were to be drawn in such a manner as to ensure that within a unit or the capital of federation, all the constituency of particular community could have, as far as possible, equal number of votes. Out of 200 seats allocated to East Bengal, 153 were reserved for the Muslim community. So, in East Bengal, there was uh, minorities were having 21% of population size in East Bengal, and the remaining citizens of East Bengal were Muslim. So, to, 153 seats were reserved for the Muslims in East Bengal according to
हाँ
their population size.
हाँ जी ठीक है ओके
According to their population size, the Muslims were allocated 153 seats in East Bengal and 24 for scheduled castes and 20 for other Hindus, one for Christians and two for Buddhists. So, in the second draft of the proposed constitution, the members of the Basic Principles Committee tried to adhere the reservations of the all communities in uh, both units of Pakistan, East and West Pakistan. Out of 90 seats allocated to Punjab, 88 were reserved for Muslims and two for Christians. There was no seat reserved for the minorities in the NWFE. Tribal areas, Bahawalpur State, Balochistan, Balochistan States, um, and Khairpur State, out of 30 seats allocated to Sindh minus Karachi Federal Area, 27 were reserved for Muslims, two for scheduled caste, and one for other Hindus. For the Karachi Federal Area, 11 seats were allocated, 10 for Muslims and one for Parsis. The allocation of reserved seats for the minorities necessarily required uh, the preparation of the separate electorates. The members of the Basic Principles Committee representing the minorities, namely S.C. Uh, Chattopadhyay, B.K. Datta, Prem Hari Burma, recorded their dissent against this provision of allocation of seats to the communities. For each of the provinces, seats, states, capital of federation, and tribal area, the word unit was used. There was to be a head of the unit for each unit appointed by the head of the state, serving at his pleasure for the maximum period of 5 years at a time. So the word used for each of the provinces unit, and each unit would have their head of the unit. That head of the unit would be appointed by the head of the state, and he shall serve as the head of the unit for 5 year term. Like we have governors these days in our provinces in Pakistan. For each unit, now we shall discuss the legislature in the units or provinces. For each unit, there was to be a unicameral legislature composed of members chosen by direct election. The number of members of the legislature of a unit was to vary between 75 and 350 as determined by a law of the federal legislature, which was also to provide for the actual number of seats to be reserved for various communities on the basis of population as far as practicable. The ministers in the units were to be collected The head of the state was to have the power to promulgate ordinances during the period when the federal legislature was not in sitting. However, an ordinance was to be laid before the federal legislature and would expire 6 weeks from its reassembly. Similar provision was made in respect of the head of the units regarding promulgation of the ordinances. So, head of the state, like we have president these days, he can promulgate the ordinances. That ordinance can be promulgated by the head of the state when the assembly is not in session, and that ordinance promulgated by the head of the state would expire 6 weeks from its reassembly when the legislature would have a new session from that date. After 6 weeks, the ordinance would expire. The similar provisions were made in the for head of the units. So head of the units like governors could also promulgate the ordinances when the provincial or units legislature was not in session. The authority to dissolve the House of People was vested in the head of the state, normally to be exercised on the advice of the Council of Ministers, where no ministry could command confidence of the House of the People. The head of the state was to be authorized to dissolve the House of the People in exercise of his discretion and hold fresh election. Similar provision was made for the heads of the units in regard to the dissolution of their respective legislatures. So the authority to dissolve the House of People was vested in the head of the state. Like these days, President have the authority to dissolve the National Assembly, and that authority is usually used, uh, exercised on the advice of the Council of the Ministers. But nowadays, that authority is exercised on the advice of the Prime Minister. The similar provisions were made for uh, in the units or provinces where governor could dissolve the uh, unit legislature or provincial legislature on the advice of a council of ministers. The judiciary was to be headed by the Supreme Court of Pakistan, consisting of a Chief Justice and 2 to 6 other judges. The Chief Justice was to be appointed by the head of the state, and other judges were to be appointed by the head of the state after taking into consideration the recommendations made by the Chief Justice. So the Federal Court was replaced by the Supreme Court of Pakistan that would have one Chief Justice and 2 to 6 more judges. The Chief Justice would be appointed by the head of the state, and other judges would be appointed by the head of the state on the recommendations of the uh, Chief Justice of the Supreme Court. The qualification for appointment as judge of the Supreme Court was to be 5 years as a judge of High Court, being barrister or advocate of 12 years standing. Provisions were also made for acting Chief Justice and ad hoc judges. The original now the jurisdiction of uh, the qualification we discussed. Now the jurisdiction of the Supreme Court. The original jurisdiction of the Supreme Court existed in case of the dispute between the federal government and one or more units, or between two or more units, as was provided in the first report of Basic Principle Committee that was reproduced in the second report of the Basic Principles Committee 1952. Appellate jurisdiction was to be conferred in criminal, civil, and other matters against the judgments, degrees, or final orders of a high court. The decisions of the Supreme Court were to be final and binding on all authorities, executives, and judicial which were required to act in its state. There were provisions for special leave to appeal against any judgment, degree, or order of a high court, review of its own judgments and others, and advisory jurisdiction on reference by the head of the states, as nowadays President also use the advisory jurisdiction by sending reference to the Supreme Court. Judges of the Supreme Court could not be now the removal procedure. Uh, the judges of the Supreme Court could not be removed except on the ground of misbehavior or infirmity of mind or body on reference from the head of the state. The alleged ground was to be inquired into by a bench of three judges of that court. Nowadays, we have Supreme Judicial Council that consider the matters regarding uh, removal of the judges. So, second draft of the Constitution of Pakistan, uh, they suggested a bench of three judges of the Supreme Court or High Court to remove the judges on the allegations or charges of misbehavior, infirmity of mind or body on reference from the head of the state. We have recently witnessed uh, a reference sent by the uh, um, uh, President of Pakistan to the Supreme Judicial Council against Justice Qazi Faiz Isa. That was that reference was dismissed by the uh, Supreme Court. So you can, if you look at this at that case, Justice Qazi Faiz Isa case, you will better understand the procedure of removal of the judges. So now there was to be a high court for each of the units of East Bengal, the Punjab, Sindh, and the NWFP. Every judge of a high court was to be appointed by the head of the state on the recommendations of the Chief Justice of the Supreme Court, who, in the case of appointment of a judge other than Chief Justice of the High Court, was required to consult the Chief Justice of High Court concerned before making his recommendations. The qualifications for the appointment uh, as a judge of a high court were to be a barrister or advocate of any high court of 10 years standing, a member of former Indian service, civil service of at least 10 years standing, having been a district judge for 3 years, for at least 3 years, having been a judicial officer for at least 10 years, like civil judges, are in the opinion of the head of the state, a distinguished jurist, uh, means any legal expert. हेलो जी जी अस्सलाम आना मैं थोड़ा बहुत 10-15 मिनट के आना are in the a judge could only be removed on the ground of misbehavior or infirmity of body or mind of its if the Supreme Court on reference made by the head of the state recommends his removal, just like the removal procedure of judges of Supreme Court, the same was adopted in the high courts. There were also provisions for appointment of acting Chief Justice and additional judges. The high courts were to have all such jurisdiction, including appellate and divisional, which they had before commencement of the Constitution, but such jurisdiction was subject to variation by the appropriate legislature. In addition, the high courts were to be conferred with power to issue writs in the nature of habeas corpus, maintenance, prohibition, covenanto, and certiorari. All these rates we have discussed in the UK Constitution. So these rates jurisdiction was additionally vested with the High Court, which was not uh, uh, with the High Court before the proposed uh, second draft of the Constitution. There were grantees to be provided to the civil servants of the Federation and the units against dismissal, removal, or reduction in rank without opportunity to show cause. Directive principles of state policy were to be made part of the Constitution. So the members of the civil servants or federation was granted uh, their job security against the dismissal, removal, or reduction in rank without giving a show cause notice. Like the first draft of the Constitution presented in September 1950, the second draft, though more exhaustive as compared to the first one, evoked the same response. This time, the reaction in the Punjab was extremely unfavorable. Like in the first report, the reaction came from the East Pakistan. Critics saw no logic in treating a single unit East Bengal of equal importance with all other units put together and regarded it as a violation of the federal principle under which all the units, large or small, should get equal representation in the upper house, as is the case in the United States and some other federations. So in United States of America, the Senate, the upper house, have equal representation irrespective of the population size of the states. So the critics criticized the the representation of the East Pakistan equal to the West Pakistan only on the basis of population size. So this reaction came from the Punjab. The critics seem to overlook the fact that East Pakistan had a larger population than the total of 9 units of West Pakistan put together. So, according to the author, the criticism of the critics was not justified because the population size of the East Pakistan was more than the population size of the 9 units of the West Pakistan. The composition and lesser powers of the upper house were also attacked. The Punjab leaders demanded representation in the lower house to be on the basis of population and in the upper house to be on the basis of equality of units and for two houses to have equal powers. So the members of the Punjab, they demanded the equal representation in the upper house like in the US Senate and according to the population size in the lower house like in the House of Representatives in the United States of America. And for, and they also demanded that both the houses should have equal powers. It may be recalled here that these provisions of the first draft had been attacked in East Bengal and the constitution framers had to modify those proposals to meet their demands. Although the new proposals were opposed in the Punjab, reaction to the second report was not unfavorable in the smaller units of West Pakistan. For instance, at a meeting held in Peshawar on 30 December 1952, the Chief Minister of the NWFP and other leaders expressed a favorable opinion in the second draft. The opposition to the second report in Punjab forced the Constituent Assembly to postpone its deliberations for, in, for an indefinite period. The country seemed to face a constitutional deadlock of great magnitude. national unity was threatened. For some time, it appeared that no compromise was possible which would be acceptable to the two wings of Pakistan. An analysis of the second draft and main objection to it revealed that while some of the objection, as in the case of the first draft, were inspired by a deliberate intention to create a constitutional deadlock, there were obvious defects in the new proposals. They may be summarized as under. So the defects in the second draft of the constitution were the draft did not acknowledge in a democratic way the fact that East Bengal had a majority of the total population of the country. It did not pay due respect to the fact that West Pakistan had the major part of the country's territory. By giving to the upper house a composition identical to that of the lower house, it made the former a weak replica of the House of the People and reduced its utility. The lack of a constitutional provision in case the two houses were unable to resolve a conflict in joint session. So the defects were as the report uh, disregarded the population size of the East Bengal. They did not mention in the report, and they also did not mention that the West Pakistan has larger part of the territory of Pakistan, and they